Doing a Facebook Live from my computer instead of usually from my phone where I usually do it. And this is the Wholesaling and Flipping Houses in New York show. I am Michael Pinter, where I teach you how to start wholesaling and flipping houses in New York, or if you are doing it already, how to grow your business. So let's talk about something that just came up, and it's an interesting question. I think I understand where the question came from, and I want to talk about why it's less applicable in New York. So in many states where the contracts are signed with the buyer and the seller without attorneys, what people do is they protect themselves, and they go, and depending on the state, depending on the county, they go and they record the contract, or they record a memorandum of contract, and this protects them from getting kicked out, but from the seller actually selling the property to somebody else, or if they do sell it to somebody else, that's going to cloud the title. So in New York, it's a very different scenario. So in New York, once a seller says yes, there's usually a big gap of time between when you get into contract. The law, I have a board here. One of my biggest categories is always sellers agree to price before it's in contract. And you don't have to do any of those things that I just mentioned in New York once you're in contract. It's impossible for the seller to get out of the contract, just like it's hard for you to get out of the contract. So you're protected. But are you protected from the seller changing his mind between when he says yes to you and when you sign your contract? No, you have no protection. So I got interviewed on a podcast today by somebody from Pennsylvania, Eric Latcha, and he said that when he leaves the seller appointment, he wants to have that contract in his hand. That's how he feels like it was a success. It's a different story in New York. It's a different world, really. And there's a lot of situations where a seller has agreed, and then there's a gap of time. Very rarely does a seller change his mind. There could be issues with his attorney. There could be legal problems. The seller starts telling him not to use you, that kind of thing. But I would say there is no protection between when the seller says yes and when you're in contract. But once you're in contract, you are rock solid. The seller cannot sell it to anybody else. You're more protected in New York than in other states, because in other states you can file this memorandum that may cloud the title, it may not. But in New York, if he doesn't sell it to you, you can put a list pendants on the property and he can never sell it to anybody else. And in general, you can sue him for specific performance for the entire dollar amount. So you are protected once you're in contract in New York. It's one of the big advantages of New York is that the seller cannot change his mind. In another state, the seller can put you in contract, call you up and say, sorry, I changed my mind, and go to contract with somebody else. It's not going to happen in New York. It's rock solid. So that's a good thing. And that's basically what the story is. You're not really protected in New York, but once you're in contract, you're very protected. So if you want to get more information about how I can help you, you can go to howtoflipnewyork.com. And if you like these videos, please click like. If you're watching on YouTube, please subscribe. And my phone number is in the show notes. If you're interested in getting more information, I am happy to help you. Thank you very much for watching.